In this podcast, we look at another basis for restitution, that being quantum meruit or quantum valibat. Quantum meruit is Latin for as much as he earned. This action allows a plaintiff to claim a reasonable payment for a service provided to the defendant. Quantum valibat means as much as they were worth. This action allows a plaintiff to claim a reasonable payment for a good provided to the defendant. I will talk mainly about quantum meruit in this podcast, but everything I say about that you can use in quantum valibat. Turning now to the elements of quantum meruit. If the defendant requests a good or service from the plaintiff, and the plaintiff provides the good or performs the service, and the defendant receives an incontrovertible benefit from the good or service, and freely accepts the good or service, in circumstances when it's clear that the plaintiff was not acting gratuitously, then the defendant is unjustly enriched at the expense of the plaintiff if the defendant doesn't pay a reasonable amount for the benefit conferred. Like all restitutionary actions, quantum meruit is a gap-filling measure where either there's no contract, or, if there is a contract, it's void, discharged, unenforceable, or just doesn't account for the circumstances of the case. In the case of Lumbers, the High Court stressed that the plaintiff must prove that they did work at the defendant's express or implied request. In this case, W. Cook Builders was a corporate group involved in construction. One of their companies, Sons, agreed to build a house for the Lumbers under an informal contract. Later, the corporate group was restructured. Sons subcontracted the building work under the contract with the Lumbers to another company in the group called Builders. Hence, the situation was that the primary contract was between the Lumbers and Sons had subcontracted the actual building work to Builders. The Lumbers, for their part, were unaware of the subcontract, had no idea that Builders even existed, and didn't know that it was Builders on their land building the home. Sons continued to request payments from the Lumbers under the primary contract, and the Lumbers paid every request until the house was complete, and, so they believed, the contract was fully performed. In the background, Sons paid Builders from time to time for the subcontracting work done. Builders was later liquidated, and it argued that the Lumbers should pay it money in quantum meruit for the benefit that it had conferred on them, that is to say, the construction of the house, which they had freely accepted. But the High Court rejected the claim. The majority emphasised two things. First, the primacy of the contracts between the parties. The court said that it's necessary to look at the legal relations between all the parties, and also that restitutionary claims can't upset the allocation of risks and obligations voluntarily agreed to by the parties under contract. The court noted that there was a primary contract between the Lumbers and Sons, which the Lumbers had fully performed by paying everything. And there was the subcontract between Sons and builders. The court said that if builders believed that it was not sufficiently paid, then it needed to sue Sons, the party who had subcontracted them to do the building work. It would make a mockery of contract law if builders could just ignore the contract it voluntarily agreed to with Sons and pursue someone who didn't know that it existed. Secondly, the court emphasised that the mere conferral of a benefit, even if freely accepted, wasn't sufficient to maintain quantum meruit. Rather, the court emphasised that any benefit conferred must be because of an express or implied request for the benefit from the defendant. Now, in this case, the Lumbers hadn't requested anything from builders. In fact, the Lumbers had no idea who builders were. Hence, if the Lumbers requested nothing from the builders, the mere fact that builders conferred a benefit on Lumbers did not give rise to a claim in quantum meruit. Even if there is a request for a good or a service, then the defendant must have freely accepted it. So if a defendant had the opportunity to reject the conferral of a benefit, but acquiesced in it anyway, then the defendant may have to pay a reasonable amount for the benefit conferred. In the case of Steele and Tardiani, Steele employed Tardiani and two others to cut firewood for him. The contract specified that the wood had to be cut to a certain length and width and stacked, and that the employees would be paid a certain amount per ton of wood cut as required by the contract. The employees cut wood, but much of it wasn't to the length and width required by the contract. A dispute arose about payment, and the employees walked out. Steele used the wood cut by the employees, even though it hadn't been cut as required under the contract. The employees later sought payment for the work that they had done. Insofar as the employees sued on the contract, they recovered nothing. They had agreed under the contract that they must cut the wood to certain specifications to earn the payment, and they didn't do that. Alternatively, they claimed a reasonable amount for the work that they had done in quantum meruit, and the court held that they could recover something under quantum meruit. Justice Dixon made the following important points about the claim. First, His Honour remarked on the primacy of the contract. He noted that, while the contract remained binding and enforceable, the employees had to point to something more than the work that they had done pursuant to it if they wanted payment. Secondly, Justice Dixon said that for the employees to receive quantum meruit, they had to prove that despite the breach of contract, Steele had waived strict compliance with it and had freely accepted the benefit of the work done by them, such that he had been enriched at their expense. Justice Dixon noted that Steele never objected to the employee's failure to cut to the specified dimensions, and thus he had waived strict compliance with the contract. By doing this, Steele had freely accepted the work done by the employees, and therefore had to pay something for it. But free acceptance isn't possible when the defendant had no choice but to take what the plaintiff had conferred and make the best of it. So, for example, in construction contracts, if a builder only partially builds a building and then abandons it, then the landowner has no choice but to accept the partially completed building. So in the case of Sumpter and Hedges, the plaintiff builder agreed to build 2 houses for the defendant. The builder half finished the houses, but then abandoned the job because he didn't have the money to complete it. The builder left behind unused building materials on the defendant's property. The defendant had other tradesmen complete the work, and in doing so, they used the building materials left behind by the plaintiff. The builder sued for an amount for the work actually done in quantum meruit. The court noted that the builder had no contractual right to a portion of the contract price. The contract was entire, and payment therefore depended upon the builder completely constructing the houses. It also noted that the defendant owner hadn't done anything to cause the builder to abandon the job, so the contract price, or even a proportionate amount of it, wasn't claimable. The claim in quantum meruit was also rejected, because the defendant had no choice about taking what had been built. So that is to say, there was no free acceptance of the work done. However, the builder was able to claim quantum valibat for the building materials left on the land and used by the landowner, probably because the landowner could have at least rejected those if he wanted. The defendant is only liable to pay restitution for a good or service if the benefit conferred by the plaintiff was an incontrovertible benefit, or in other words, an undeniable benefit. So, objectively, the defendant must have been benefited by the good or service, and this is just a question of fact. Justice Young provided the test as follows. The principle, as I understand it, is that if one asked the reasonable person on the Bondi bus whether the benefit which the plaintiff conferred on the defendant was a benefit to the defendant, the reasonable person would say, "Of course." Incontrovertible benefits tend to be benefits conferred on the defendant, which the defendant has either converted into money or which are readily converted into money. So in Steele and Tardiani, the defendant employer realized an incontrovertible benefit when he sold the wood chopped by the plaintiffs. But they can also include the provision of services which have objectively benefited the defendant. And lastly, it must be objectively apparent that the plaintiff wasn't acting gratuitously when they provided the good or service. So, for example, if I give something to my mother for Christmas, that doesn't oblige my mother to pay a reasonable amount for the thing I gave her, because it's clear that it was a gift. Similarly, if I ask to borrow your pen and you let me use it, that of itself won't oblige me to pay you for the use of the pen. Again, it must be apparent that you weren't acting gratuitously. Even in commercial contexts, it's clear that not every request for a good or service fulfilled obliges the requester to pay something for the good or service. So, for example, if a company calls for tenders and a supplier spends time and money responding to that request by preparing and submitting a tender, that doesn't oblige the calling company to pay the applicant for the time spent on preparing and submitting that tender. In Brenner and First Artists Management, Justice Byrne said that the test is whether the recipient of the services, as a reasonable person, should have realized that a person in the position of the provider of the services would expect to be paid for them, and didn't take a reasonable opportunity to reject those services. So if the reasonable defendant wouldn't have realised that the plaintiff expected payment, then the defendant isn't obliged to pay for any good or service rendered. If the plaintiff successfully argues quantum meruit, or quantum valebat, then the plaintiff is entitled to reasonable remuneration for the good or service provided by the plaintiff. Reasonable remuneration means the market value for the work done at the time the good or service is accepted. And evidence that may be relevant to an award is the actual contract price agreed, if there is a contract, and the expenses incurred by the plaintiff. I mentioned earlier that it's possible to claim quantum meruit if the parties are in a contract when the contract is discharged for breach or frustration, is void or unenforceable. The contractual context is apt to a claim for quantum meruit because, firstly, the request for the service is the contract itself, and secondly, it's clear that the parties didn't intend the services to be provided gratuitously. However, the existence of the contract between the parties can complicate two things. Firstly, whether the plaintiff can claim in quantum meruit, and secondly, how much the plaintiff will receive in quantum meruit if they're able to make the claim. We will now look at quantum meruit claims in three contractual contexts. The first is where a service provider terminates a contract because of the client's breach or repudiation. The second is where the client terminates a contract because of a service provider's breach or repudiation. And the third and final context is where the contract is void or unenforceable. If an innocent service provider terminates a contract because of the client's breach or repudiation, then the service provider may freely choose to either sue for contractual damages or to sue for quantum meruit. The innocent service provider can freely choose quantum meruit because the court deems that the work done by that service provider both benefited the defendant client and was freely accepted. Now, typically the service provider would choose contractual damages because damages put the plaintiff in the position that they would have been in had the contract been performed. So if the service provider anticipated making a profit from the contract, well, then it will sue for damages. But if the contract was loss-making, then prior to the 9th of October 2019, they could have elected to sue in quantum meruit for a reasonable amount for the work done, if that would have resulted in a higher award than a claim for contractual damages. Prior to the 9th of October 2019, it was routine for innocent service providers to elect to sue in quantum meruit if such a claim would result in an award higher than a claim for contractual damages. The different outcomes were justified on the basis that they were different causes of action, which led to different remedial outcomes. If a plaintiff is fortunate to have two causes of action available to him or her, then it's the plaintiff's privilege to choose the most beneficial cause of action. However, on the 9th of October 2019, the High Court in Mann and Patterson Constructions limited how much an innocent service provider could claim in quantum meruit. Now, why did it do this? Well, recall from contracts that termination of a contract for breach or repudiation does not void it. Recall that termination releases the parties from further performance, but the contract remains binding on the parties. Now, in theory, if the contract is still binding despite the termination, then the plaintiff's only remedy should be contractual damages. Because recall that you can't maintain an inconsistent restitutionary claim against a binding contract. So in the case of Mann, the High Court answered the questions of whether the plaintiff service provider should be limited to just a claim for contractual damages, and if the plaintiff service provider may choose to sue for quantum meruit, whether that claim should be limited. A majority held that the innocent service provider could still freely elect to sue in quantum meruit or for contractual damages. So the innocent service provider after this case can still freely elect to choose between those two causes of action. However, the court recognized that it seemed unjust that a plaintiff service provider could claim in quantum meruit and be placed in a position better than he or she would have been in had the contract been performed, in circumstances where a contract that is terminated for breach is still binding and enforceable despite being terminated. Therefore, it held that if the plaintiff service provider terminates the contract because of the client's breach or repudiation and elects to sue for quantum meruit, then the service provider's claim in quantum meruit will be limited by the agreed contract price. So the innocent service provider can still, as I said, freely choose to sue in quantum meruit, but the amount the service provider receives will be limited by the contract price they agreed to. Turning now to the context of a contract that is terminated by a client because the service provider breached or repudiated it. In this context, it is much harder for the defaulting service provider to sue for quantum meruit for the work that they had done prior to the contract being terminated by the innocent client. And there are several reasons for this. The first is that the defaulting service provider comes up against the rule that a plaintiff can't maintain a restitutionary claim that's inconsistent with the binding contract. A rule which tends to be overlooked when an innocent service provider elects to sue in quantum meruit. So, for example, if a plaintiff agreed under an entire contract to build a house for $100,000 and they only build 80% of it before defaulting, then the plaintiff can't maintain a quantum meruit claim to claim for the work that they'd done. They'd agreed under contract that they'd not be entitled to any payment unless the entire house was built. So in this scenario, just like the employees in Steele and Tardiani, the defaulting party must show that their right to quantum meruit arises outside the contract. The second reason is that a plaintiff must show that the defendant received an incontrovertible benefit from their defective performance. So if the service provider has defaulted on a contract and is seeking quantum meruit, then the defendant client will argue that an incompletely performed contract is of no benefit to them. the defendant client must have freely accepted or acquiesced in the non-conforming work done by the plaintiff service provider. Now, if the defendant had no choice but to take and make the best of the plaintiff's incomplete performance, then just like in Sumter and Hedges, the defendant isn't liable to pay for the goods or services rendered. But in the rare case that a defaulting service provider is able to claim in quantum meruit, the next question is whether the defaulting service provider's claim ought to be limited to the contract price. Now, this question wasn't addressed in Mann because that case considered only the rights of an innocent service provider terminating a contract because of the client's breach or repudiation. But I would submit that a claim by a defaulting service provider is limited to the contract price. It would be extraordinary if a defaulting party could claim more than an innocent party. And finally, we'll look at the context of where the contract is unenforceable or void as opposed to merely terminated. Does it make a difference? Well, in this case, the claim for quantum meruit is clearly available because the contract has totally failed. And it seems the claim is not limited by the contract price. So the plaintiff will receive fair market value for the work done, and the contract price is just evidence of what fair market value may be. It doesn't limit the claim, like in the case where the contract is merely terminated. A recognized exception to the request principle is the doctrine of necessitous intervention. If a plaintiff incurs an expense in an emergency to protect the defendant's property, then the defendant may have to reimburse the plaintiff even though the service was not requested and not freely accepted. It's a curious principle because generally the law doesn't allow a plaintiff to impose liability on the defendant without the defendant's consent. Nonetheless, it's well recognized, and even the majority in Lumbers recognized this exception. The principle developed out of maritime law. There, ship owners could sue the owners of cargo for reimbursement if, because of an emergency, the ship owner had to incur expense to protect the cargo owner's property. That maritime principle was applied to land in the case of Great Northern Railway Company and Swaffield. In this case, Swaffield arranged for his horse to be transported by train to a certain destination. The train arrived late at night, however, no one was available to collect the horse, so the railway company had it stabled nearby. The defendant's servant then arrived, but refused to pay the stable for its service, and so left, leaving the horse behind. The defendant left the horse at the stable for the next 4 months, all the while refusing to pay for the stabling service which he felt had been foisted upon him. Eventually, the railway company paid all outstanding fees to the stable and had the horse delivered to the defendant. It then sued the defendant for reimbursement. The court held that the defendant had to reimburse the railway company. The company had incurred an expense in an emergency to preserve the defendant's property, therefore it could claim restitution from the defendant. There are very few cases on necessitous intervention which highlight just how exceptional it is. The general rule remains that it's not possible to foist liability on someone who hasn't consented to it. However, a few more principles have developed. First, you can't claim necessitous intervention on behalf of a stranger. So in other words, there must be a pre-existing relationship between the parties. Typically that relationship will be something like a bailment relationship or an agency relationship. Secondly, there must truly be a necessity for the service bestowed by the plaintiff. Thirdly, the plaintiff must have been unable to communicate with the defendant and hence had to act without authority. Given that the world is now mostly online and instantly accessible these days, query whether we'll see any more cases of necessitous intervention. And fourthly, the plaintiff must have acted in good faith. So that completes the overview of quantum meruit and quantum valibat. The last topic to look at in restitution are the defences.